Hello, happy New Year's Eve. I hope you are doing well. It's the afternoon. It's just it is now 1:10 p.m. in Melbourne, Australia. I hope you're doing well. Yeah, I'm still getting moving. I've done a little bit of cleaning today, but anyway, I've discovered. Well, I saw that there was a new filing today that hit. So over probably the next few days, we will see some filings as their process jump up. So it's something we have to check today. So we've got the motion summary judgment still happening on the 6th of the 1st. And then we've got this memorandum. So there's been 142 documents so far filed in this case. Okay, so this is number 142 at the moment. And it's a memorandum. So it's a memorandum, reply memorandum for the defendant's motion for summary judgment. So what happens is that a party files a motion, the other party gets to respond to that, and then finally the party that filed it gets to respond to the response. So this is their response, 7M's response to their motion of summary judgment. This, by some minor miracle, is 8 pages. So also just bear in mind that we've got 7M as the plaintiffs and Catherine Mansky-Polson and Without a Crystal Ball as the defendants. Okay. I haven't seen it. I've seen little bits. I've seen clips of it around the place. And so remembering who the plaintiff and defendant is going to be very important here. So defendants, Catherine Mansky-Polson, a.k.a. Katie Joy and Without a Crystal Ball, submit this reply memorandum of law in support of defendants' motion for summary judgment. Throughout this case, defendants have aggressively asserted their First Amendment rights to report on matters of public interest. Plaintiffs concede that they are public figures, and thus they can only recover from defendants if they can prove actual malice. Let me just stop there. Have they conceded that they are public figures? I don't think that they have. I think they questioned whether they were or not. And if I'm rightly, the court said that that was something to be determined. But definitely Miranda and James, I would say yes. Robert Shin, I'm not sure that you can. So I don't know, but it says plaintiffs concede they are public figures and thus can only recover from defendants if they can prove actual malice. The defendants knew or acted with actual malice that defendants knew or acted with reckless disregard of the truth. Plaintiffs have produced no evidence that defendants knew that the statement they made was false. They have also not presented any evidence that defendants acted with reckless disregard for truth. In fact, they have produced scant evidence that would even support a claim that the statements defendants made were false. Defendants could have established absolute malice in a number of ways. Hang on, isn't it the plaintiffs? Hang on. Defendants could have established absolute malice in a number of ways, but they relied on their own conclusion statements made without foundation as to Ms. Polson's knowledge or the process she took to include. This should be plaintiffs, shouldn't it? Hello, Aussie boy. These should be plaintiffs. Because why would Katie be having to prove malice? So this should be plaintiffs could have established absolute malice in a number of ways. So it doesn't help when a lawyer doesn't know whether they're the defendant or the plaintiff, I guess. It's a bit tacky. Happy almost New Year. Yes, happy almost New Year to you, Aussie boy. Has anyone got plans for New Year's? Hello, Laura. How are you, Flame Mum? So here we go. So I've highlighted this word. So I've highlighted the word defendant. It actually should be plaintiff. If you actually read it as it says, So they've said plaintiffs, so we'll go back to this line here. Plaintiffs have produced no evidence that defendants knew any statement they made was false. They have also not presented any evidence that defendants acted with reckless disregard for truth. In fact, they have produced evidence that would even support a claim that the statements the defendants made were false. Hello, Anne. Hello, Barbara. Defendants could have established absolute malice in a number of ways, but relied on their own conclusory statements made without foundation, as to Miss Paulson's knowledge or the process she took to secure the information reported on. So this actually should have been plaintiffs. Plaintiffs could have established malice in a number of ways. Why is Katie trying to establish malice? Anyway, I'll get off that soapbox. Recovery on all of plaintiff's claims rely on the ability of plaintiff to establish that defendant's statements were defamatory. Defendants understand how difficult a task this might be. See, plaintiffs have alleged that 86 statements are actionable, and there may be significant confusion as to what statements are at issue. However, plaintiffs have not cleared this up through any sort of factual analysis, instead submitting a memorandum that leaves out a factual summary that is generally required under the This is a substantial departure from the summary judgment standard, which requires the non-moving party to present evidence sufficient to establish any disputed issue of fact. Okay, so what they've said is the plaintiffs have not cleared up any. Well, what haven't they cleared up? Just to say they haven't cleared up any evidence and that there's no factual summary. The judge now actually has to go through it, and normally you would put examples of that. The end result of this analysis supports the conclusion that plaintiffs are seeking the least expensive way to make defendants an object lesson for other media who seek to report on plaintiffs' activities. Either shut up or pay an ungodly amount of money to assert your rights under the First Amendment. So the argument, defendants are entitled to summary judgment on plaintiffs' defamation claim. Plaintiffs have not addressed the fact that their absolute malice analysis relies on the incorrect standard. Plaintiffs' memorandum opposing summary judgment has one glaring admission. It fails to address the fact that they have misrepresented to the court the appropriate standard to establish absolute malice. As in defendants' memorandum supporting summary judgment, plaintiffs have consistently relied upon the formulation for common law malice rather than the Supreme Court's required formulation for absolute formulation. What does that sentence even mean? The difference between the two standards, in common law malice, a plaintiff may rely upon extrinsic evidence to meet the burden of proof that show ill will and improper motive, such as exaggerated language, the character of the language used, the mode and the extent of the publication, and other matters in excessive privilege. In contrast, under the absolute malice standard, a plaintiff must show that the statement was false and was made with actual knowledge that it was false and that it was made with reckless disregard of the truth. Plaintiff's argument here relies on the contention that the defendants did not address in great detail the basis of their reporting. This is simply not true. In all cases, defendants identified the basis for their reporting. It now falls to the plaintiffs to prove that Ms. Paulson knew what she was reporting was false, or that it somehow was reckless for her to conclude that her reporting was true. The plaintiffs have failed to do so. Defendant motions for summary judgment fully complies with Minnesota R56. Plaintiffs first make the pedantic argument that the defendant's motion for summary judgment should be dismissed because they claim defendants have failed to specifically identify which defamation claims they seek to dismiss. Lest there be any confusion, defendants seek summary judgment on plaintiffs' claims for defamation, count 1, defamation per se, count 2, and commercial defamation, count 4. Rule 56 does not require some precise formulation of the motion and memorandum. Rather, it is designed to ensure the court understands exactly what claims are implicated by the motion for summary judgment. In this case, defendant's motion seeks complete dismissal of plaintiff's amended complaint. Defendants addressed the elements of defamation. Hello, Michelle. Elements of defamation consist of their burden of proof. Plaintiff's next argument is that the summary judgment should be denied because defendants have failed to address the common law elements of defamation. Defendant's memorandum supporting summary judgment identifies the common law elements of defamation on page 54. To establish a defamation claim, plaintiff must prove 3 elements. The defamatory statement is communicated to someone other than the plaintiff. The statement is false, and that the statement tends to harm the plaintiff's reputation to lower the plaintiff in the estimation of the community. Defendants did not address these elements in detail because they are irrelevant if the statements are privileged or are otherwise not actionable. Unlike plaintiffs, defendants did address each post plaintiffs claimed to be defamatory, where they could be found after a thorough search, set forth the description of the post in the amended complaint, the basis for the reporting, as well as any other information relevant to the issues of privilege, truth, or the other defences to defamation. Plaintiffs identified more than 86 statements in the amended complaint. It would have been impossible to discuss these details in any details within the 35-page limit. Didn't they do 68 pages? And the Minnesota Gen R Prac, whatever. Even plaintiffs struggled with this limitation, apparently reducing the number of alleged statements to 21, and failing to separately address each statement in their memorandum supporting their motion for summary judgment. Plaintiffs specifically claim that the defendants have failed to address whether the statements of the amended complaint are true. This argument, the argument relies upon an incorrect formulation of the burden of proof. To establish a claim of defamation, plaintiffs are required to establish that the statement is false. Yet plaintiffs have produced scant evidence that what defendants said was false. In fact, defendants acknowledge only one false statement, that the Derricks were not married. And that statement was based on the Wilkins video where Miss Derrick's family stated they did not know if the Derricks were married. 2, the fact that other 7M dancers were holding themselves out of being married to each other when they were married to other individuals. And 3, statements by Lydia Chung that church members are required to partner and unpartner at the direction of Shin and other church leaders. That is what she's saying was the argument for stating that the Derricks were unmarried. But I don't know how those 3 statements gets to the justification that you could say that the Derricks are unmarried, but weren't married. Plaintiffs have failed to establish that Paulson's statements tended to harm their reputation. Certainly, there was a maelstrom of media attention after the Wilkin video, with several bigger outlets other than Without a Crystal Ball covering the Wilkin family video and allegations made therein. The court may take judicial notice of the reach of some of these publications. Rolling Stones, for example, has 32.8 million page views and 425,000 print subscribers. It is a magazine of historical influence, a monthly must-read publication from my youth. A Netflix documentary, Dancing for the Devil, was in the top 10 series list for several weeks and reached the top 1 spot at least 1 week. What? That makes no sense. Dancing for the Devil was in the top 10 series list for several weeks and reached the top 1 spot at least 1 week. Has she mentioned that she's the archival consultant and that was based on all of her information? Oh, wow, it's 9:23 on the December 30 now. Cool. That sentence makes no sense. And why would you put I don't know where you... When I went to school, we were always taught you never start a sentence with after a full stop with and. And the Netflix documentary Dancing for the Devil was in the top 10 series list for several weeks and reached the top 1 spot at least 1 week. These publications, but don't forget, Dancing for the Devil was the last of what to be released. So to quote Dancing for the Devil was not part of the lawsuit aspect either. But because now it's been mentioned, it could be fair game now. These publications reported many of the same claims that were discussed without a crystal ball's coverage. Shin and 7M have sued other small publishers for covering them, but they've not sued any larger publication. As I said, Dancing for the Devil was based on the research of Katie Joy. So if she's found to be, let's just say they find one element of defamation, that if the judge says, yes, I find this statement defamatory, that actually then could give 7M and Robert Shin cause to go to Netflix, because even if they find that one thing that she said was defamatory, then they could say that Netflix didn't do their due diligence and it was all based on defamatory information. So it could be that they're waiting for this a little bit longer. But anyway. At best, plaintiffs have presented conclusory statements that they suffered reputational harm at the result of WOACB's media coverage. Plaintiffs have declined to produce tax returns that might establish financial harm suffered by them. They failed to present evidence that brands have chosen not to work with them as a result of WOACB's coverage. Segue. Only 7M had to provide financials. The plaintiffs didn't. Remember? Do we have to go back and read that document where they lost most of their discovery claims? While plaintiffs do not have to establish reputational harm to meet their burden of proof with respect of defamation per se and commercial defamation, they still have to produce proof of damages. Well, the fact that business is closed is actually like the fact that 7M no longer trades due to the reputational harm, I think would be evident. I started following this channel and she's put a couple of videos saying KJ got the car struck by the sun and in touch. I wonder. I heard that she got struck by the sun, but I don't know anything or how that has come about. I don't know any details on that. So their failure to provide tax returns or updated financial data is fatal to their defamation claims. They don't have to provide anything that they've not been told that they had to provide. The court said that they didn't have to provide it. I don't know why. To use a quote, flogging a dead horse. They keep going on and on and on about this same thing. They keep bleating on about the fact that they haven't, that they haven't done X, Y, Z, when in fact, they didn't need to give them all of that information. Defendants are entitled to summary judgment on plaintiffs' tortious interference with contract and intentional interference with prospective advantage claims. Plaintiffs appear to assert that defendants failed to assert through a specific analysis of each element that is entitled to summary judgment on plaintiffs' tortious interference, contract, and intentional interference with prospective advantage claims. In fact, defendants' memorandum fully sets forth the elements of these claims and addresses the rationale for requesting summary judgment. The basis of the defendant's motion is that one defendant's conduct was fully protected under the First Amendment, and Paulson's statements were privileged under the First Amendment, that she made no direct contact with any organization. A call for a boycott is protected under the First Amendment. And even if plaintiffs were able to establish that Paulson did make contact with these organizations or that her followers made such contact as a result of Paulson's request, such contact was justifiable by the refusal to deal doctrine, which states that in order to be actionable, the contact must be more than a simple statement that the person making the contact will refuse to deal with the organization. The refusal to deal doctrine defeats the element that provides that the interference must lack justification. Plaintiffs do not address defendants' motion to dismiss their claim for intentional infliction of harm, emotional distress. Defendants assumed, based on plaintiffs' failure to provide discovery relevant to intentional infliction of emotional distress claim, that plaintiffs have abandoned this claim, although plaintiffs did not confirm this in their memorandum of law. Their failure to address the issue should act as a waiver of the claim, and summary judgment is appropriate. Again, I don't think that they had to, from memory, I don't think they had to prove anything to do with their mental health status in discovery. Defendants are entitled to summary judgment plaintiffs' claims for negligence per se. According to plaintiff documents, defendants failed to provide legal authority for the claim that the violation of an unconstitutional statute cannot be the basis of civil liberty liability, and a summary judgment is inappropriate. However, plaintiffs have provided no authority to establish that the unconstitutional statute may form the basis of civil liability. This is a rather extraordinary argument to make without any legal authority. How can plaintiff establish violation of a statute if the statute they cite exceeded the legislative authority under the Constitution? This is a great big gigantic word salad, in my opinion. Absolute gigantic word salad. I think they need to use they need to put their paragraphs into Chat GPT and say summarize this. Defendants are entitled to summary judgment on plaintiffs' deceptive trade practices. Plaintiffs contend that defendant applied no law or fact to establish their claim that they are entitled to summary judgment on plaintiffs' deceptive trade practices claim. This is untrue. In fact, defendants cite, they've got a case there, for the proposition that the Deceptive Trade Practices Act does not alter the plaintiff's burden of proof that the statements made were false or otherwise actionable. Actually, the plaintiff's amended complaint makes analysis of the specific factual basis for the plaintiff's deceptive trade practices difficult, since it does not identify with specificity which statements form the basis of this claim. That said, defendants are the only parties to this lawsuit who have attempted to address the factual basis for each statement asserted by the plaintiffs to form the basis of summary judgment. Defendants are absolutely entitled to use plaintiff's failure to comply with the court's discovery orders as a basis. But plaintiff contend that defendants are attempting to bring a discovery motion after the close of discovery. However, defendants have already brought their motion to compel and obtained an order compelling discovery. At this point, it is now proper to address the consequences for plaintiff's non-compliance. If this lawsuit proceeds to trial, defendants will bring a motion in limine to exclude all evidence of damages. That would, in essence, decide the case, since all the plaintiff's causes of actions require plaintiff prove they were damaged by the defendant's actions in some monetary amount. The argument is also appropriate to address on summary judgment. Plaintiff's failure to produce compelled evidence places extreme prejudice on a party that may be asked to spend the sums necessary to prepare for what would be a very expensive trial. Based on the foregoing, defendants request this court make their summary judgment. Well, wasn't it 7M still trying to get stuff from Katie at one point in time? So, because we've got 140, we've got 140 documents here filed. So that's their response. Now, because there should be another one probably coming, because 7M also filed a summary judgment. Yeah, yes, you agree? Yeah. I thought that there was still correspondence, and one of the reasons why 7M wanted the summary judgment was that, well, look, whether or not, I don't know whether what 7M produced, whether they produced all of their documents or whether there's some outstanding. But what I know is that Katie had a lot more documents she had to hand over than 7M had to hand over. And she was denied. She was denied a lot. You are correct. Yes, they wanted to know her bought subscribers, how many subscribers she purchased. So according to WOACB, let's have a look. This is very interesting. I mean, talk about obsession, and this she's kept off YouTube. Katie Joy from Without a Crystal Ball has done 70 TikTok lives, averaging 3 hours each. That's 210 hours. That's equivalent to 8.7 consecutive days of non-stop yapping about Gypsy Rose. So Lama Gill says, okay, I just counted, and KJ has done, as of today, this was yesterday, 70 lives on Gypsy Rose Blanchard on TikTok. I'll add the hours up tomorrow, as it's going to take me quite some time, and I'm exhausted. Let that sink in. Katie has done 70 lives as of today on GRB. Yeah, she calls all of us insane and obsessed. Joanne, the last documents you read that were like 66 pages sound like a first grader written them. Is it possible? I think it is possible that she wrote it. So some people like to write their own documents to cut down the costs, because if lawyers, whatever the lawyer touches is paid for. If they have to read something, it's billable. If they take a phone call, read a text message, whatever a lawyer does regarding the case is billable. So it is quite possible that she's written it to save time. Now, most lawyers would read it and it would still, it's legally okay to do it. But you just have to, they have to, at the end of the day, it's got their name on it. So whatever the outcome is, they're responsible for it because they've got to put their name to it. So a lot of lawyers will do a final edit, and they will ensure that it's written properly. And so they often say that might only take me 2 hours or that might take me an hour to edit the document. So I'm only going to charge you for an hour of work to put my name on it. But so I mean, if she has written it and the lawyers put her name on it, and as you said, it sounds like it's been written by a first grader, that's the lawyer's reputation. If you look at Amber's court file, if you look at her court filings, you can tell that's written by a lawyer. I mean, one of the things that we have to do as law students, we have a strict word. They give us strict word counts, usually at the lower limit, because you have to learn to be able to make your points succinctly. So you need to be able to make it quickly, succinctly, and with evidence. So you can't go on 5 or 6 pages for one point. It would be 2 or 3. You've got to be able to do a paragraph because there are limitations. You know, if you've got 35 pages to put your argument, you have 35 pages in which you have to do everything. So you have to learn how to shorten everything as quickly as possible. Yeah, look, I think that one may have been written. It was very repetitive. But there, where there was confusion over whether I used to have to meet with lawyers a couple of days ahead to go through everything before appearing on behalf of company or agents. Yeah. Yeah, and details matter. Well, that's right. Details do matter if you want to win. If you want to win, details matter. And I often say, if you think you're going to win, right? Does it matter if your lawyer writes everything and incurs the cost because you'll get it back? Often people with no or very little prospect are the ones that. So this to me is really embarrassing to have actually confused defendants and plaintiffs, because I've read that 2 or 3 times now and it doesn't make sense as it says. But It also saying that the defendants, so Katie, could have established absolute malice a number of ways, but they relied on their conclusions made without foundation. So, and look, you are always going to get some typos and some grammar errors in legal documents, because sometimes they are done. There are some documents that are done, that you're in court during the day and the judge says, I need this done by midnight tonight. So you have to quickly churn out a document, and it has to be proofread and edited all before the deadline. When they're done very quickly like that, there are often mistakes, but they don't make mistakes like this. In my opinion, these types of mistakes should not actually ever happen. And as Miss Balls has pointed out, she has failed to state that she broke the story. She has admitted, and she even admitted on the podcast she was on, that she broke the story. And then she gives, Miss Balls gives proof of Katie admitting to writing a monthly must-read publication from my youth. And she's saying that line could prove that she wrote it herself. So let's have a look at that when we get into Rolling Stones. Where are we? Yeah, here we go. So we get to this one here. Rolling Stone, for example, has 32.8 million page views. It is a magazine of historical influence, a monthly must-read of publication of my youth. That you wouldn't write, normally you wouldn't actually read that. You might have put a must-read publication from the 80s or something. Like, you don't generally use first person. You wouldn't normally write this. So if I was editing that, if I was editing this document for court, this would be out. Then I wouldn't have this, and I'd be putting a comma. The Netflix documentary for that was in time, and then this doesn't make any, and reach the top one spot for at least 1 week. So all of this, these would need to be rewritten to make sense. And so again, they're going on about tax records. So I don't know why they're saying that the failure. I'm sorry, I think a judge could. Well, you'd have to, but see, at the end of the day, as I said, it's got Jennifer Moore's name on it, and she's acknowledged. No, so there's a lawyer's name on it, and I don't know. I mean, I don't know that I could really put my name to it in that format. And this failure to comply is going to be very interesting, because, again, the judge would know who's failed to comply. I don't think she was granted a lot. She didn't get a lot of what she requested. I know, yeah, a first person reference. And the only time you generally use first person references is if you're writing an affidavit or you are quoting something that somebody has said and they've talked about themselves. That's the only time in court documents that you would use first person, is usually in affidavits. Or you've made a point and you're quoting somebody and they were talking about themselves. And the quote uses I in first person language, but she's written it like she's speaking to a chat. Yeah, well, it's very wordy. It is very wordy. And I think you can even tell where the edits have taken place. Let me just show you something. Okay, so here the writing's different. Okay, so that I reckon has been edited, so they've put that in. There was another one when we got to the Rolling Stone section. Let's see if I can find it. There was a bit here I saw. Oh yes, here. The font is different. See how the font's completely different? See how there's two different fonts here? In this here? It's been edited. So they've added the word essence and of plaintiffs. And then argument is also appropriate to address on summary judgment. So you can see that the font has changed in some parts. And like you can see that they're complete, like there's big, yeah. Anyway, that's just and again, these are my opinions based on my study as a law student. So 56. So this was filed at 1:07 p.m. on the 30th of the 12th. So I don't know whether we're going to get any more before the trial, but we're getting close to it. I'm just wondering whether she's going to attend court or what excuse we're going to hear about her not being able to attend court. So it says, motion summary, she included a bunch of pages that were a case that are prevailing for. Yeah, I don't know the point of adding something that, because if he's prevailed and he's won, then all the points from that lawsuit that say that he did a certain thing are wrong. All right. So it says there's the courtroom. So it was originally supposed to be on the 25th of the 11th. But it's at 9 a.m. Ooh. I don't know about annoying the judge, but it's annoyed me. All right. So yeah, so that's where we are with all of this. It's crazy. And Miss Balls is having a field day here. She's got here. Katie's defense is that it's irrelevant because it's journalistic privilege. Right? And about the 35-page limit. She filed a 66-page. She filed a document with 66 pages. What are my thoughts? My thoughts are wordy. So the next stage to see if the summary judgment will prevail. And I have said that I think, in my opinion, there are too many questions that need to be decided on by the court. Yes, I did read opposition reply. In my opinion, the fact that the court needs to decide whether she's journalist, the court needs to decide whether the Derricks and Shin are public figures, and the court needs to decide whether Without a Crystal Ball is a media outlet. If the court decides those three things, then probably her defense and everything stands. But if, for example, the court says she's not a journalist, Without a Crystal Ball is not a media outlet, and that even if the Derricks public figures but Shin's not, then it changes the whole. It has to change how the case proceeds, because then she can't use qualified privilege. She can't use her journalistic privilege. So I can't see how the judge can give summary judgment when those major factors haven't been agreed on. That's just my opinion. Wordy. What else did I say? Wordy. So that is my. Yes, Amber has included her underprofessional drunk lives, and yes, that's right. Well, and also remember, because she's been going after Gypsy Rose and she's spent on TikTok, she could easily say, well, look, if you want current evidence, here's her behavior on TikTok. Well, the whole thing about malicious is she did post on Instagram, remember, that she made a promise to the Wilkins. So if you've promised that you're going to help somebody get their child back, does that mean that you may have a reckless disregard for the truth in order to help the people? You see what I mean? It may not have been, the intent may not be malicious, but because she's believing what the Wilkins is saying, she's blocked her way. She's blocked her vision off to what the truth could be. The truth could be somewhere in the middle, but because she's adamant that the Wilkins are right, she's recklessly disregarding the truth. That's my opinion. All right. So Miss Balls has shared some stuff because remember, Camille's now not flavour of the month. So, oh, drama, forgive me. I'm going to try to explain it best I can. This is between Katie Joy and her panel on TikTok. They can do it. So if it comes down, usually when you're talking about damages and they look at whether the behavior is going to continue, they can bring it up. I'm not sure what the law in Minnesota is about current conduct. Generally, current conduct doesn't, even in criminal cases in Australia, other cases can't technically be used. But generally, current conduct is used for compensation. If, for example, Katie was to say, well, I don't act like that, or if there is a way, so sometimes, if it's brought up in the court, it could be, and she says, well, I'm not like that, I'm very professional. And yes, doesn't KJ have to open the door for it to be used in trial? Yes, she does. So if she opens the door for it and she says, well, I don't behave like that online, or I don't obsess over people, she's opened up that door, and they go, well, actually, do you realize you've done 70 lives on Gypsy Rose, etc., etc. So this says, Camille, this message is from me on behalf of myself and my moderators. We have no ill will with you. We simply do not want to engage with anyone that is abusive to us in our DMs. I'll respond to you privately after you sent me 3 pages of abusive messages and threats. I won't be threatened to respond, or else you'll go on other panels to talk about me. I have a specific way I run my panel and my page. I decide who is on my panel and who is not. I drop people off my panel when they cannot stay on topic or they are causing chat frustration. That way, the way you have treated my moderators, Ray and Faith, is unacceptable, abusive, and disturbing. Neither of them did anything to you, nor do they deserve to be threatened by you in DMs. There's no drama here. We made a boundary that we do not want to engage with you due to your behavior. That is all. Do not contact us again, Katie Joy. All right, what's the next one? Oh, gee whiz. I want to start. I want to start off by saying I support all women on this app. What I do not support is people who are accusing and attacking other women. I am who I am in person as I am on this app. I am not two-sided to me. There is no side to begin with. Accusing someone of something they didn't do while simultaneously posting messages that was sent in confidence goes to show the characteristics of an adult having childlike behavior who claims he's a professional journalist. Someone who is a professional journalist also wrongfully kicking people off because of different in opinion. Knowing well enough you can speak to somebody like an adult, you blocked and posted messages, live trash talk another woman who has stuck up for you in the past, mind your previous behaviors. You call yourself Switzerland, but Switzerland is someone who would have an adult conversation instead of trying to defame someone. After meeting me, I let everyone know, leave you alone, because clearly what everyone is telling you is something you can't handle. Like I said in the text to you, maybe you need a mental break or someone to talk to. Don't think you were crazy. Maybe my mind's changed. Just remember, you're doing one thing on this app, bringing awareness about Gypsy Rose. If you're going to just be as bad as Gypsy, maybe you should be talking about her. One more thing is, I'm not butthurt over being kicked off your panel. I'm outraged to the 40-year-old woman like yourself with a child behaves childlike yourself. Someone who is a professional journalist doesn't behave in this manner, especially over differences of opinion. The true journalist gathers all the information before trying to defame someone or cause trauma. True grown women don't behave like a child from middle school. Don't forget, not only does a true journalist collates information, they also give both sides of the story, and it's up to the audience to decide what they believe. Girl, what the hell did you do? I didn't do anything. Katie did something, though I called her out. You agree on both sides, right? You don't even know what happens. I just saw what you did. Not anymore. I'm siding with Katie. Fun fact, you wouldn't even get to see what happened. I called Katie out on her nonsense because she said about Ivory, I really did not want to pay hacker. She's using words to try and manipulate the hacker to get him to come into her account on her live to see what he would say. She was trying to feel him out. Katie wasn't even in Ivory's live long enough to see what actually happened. She took what she saw and ran with it and went live. Yeah. So there's been a big fight. Yeah. Okay, so then Camille was kicked off and blocked by Katie for letting KJ know she was wrong about Ivory not wanting to send Gypsy's hackers money. Camille reached out to both of them, and Ray and Faith were mean girls. You're not casted on. Katie shared everything you sent because you were upset that you wouldn't get girl, this is not mentally, so they're calling this mentally unstable. You don't even know Katie. I can think for myself when it comes to Katie, and you need to get some help. I've been working on my mental health too long to be wrapped up in this juvenile behavior. This is what whoever this is, Ray, has said to Camille. Ray's such an utter clam kisser, even though KJ is mean to her, and Faith was kind to Camille and sent KJ all the DMs and gaslit. Of course, they're all screeching. Camille is threatening them. You watch, Camille will be the next hacker. I mean, we knew that was going to happen, didn't we? And remember, she doesn't do drama. Katie doesn't do drama, remember? She doesn't do drama. She's... No one else that I follow find themselves in this kind of mess over and over again. Yeah. She does have a lot of drama follower. And unfortunately, we know that we know it's never her fault. Someone always manipulates her as well. So don't forget all of that. So, yeah. And I think, talking about the summary judgment, I think another, so it's got to, you have to have undisputed facts for there to be a summary judgment. I think one of the disputed facts is whether 7M, one of the facts that is disputed is whether 7M and Shekinah Church are the same entity. Because if they are the same entity, if the judge rules it, then a lot of stuff that she said could be deemed in. But if, for example, the judge says, well, 7M, and I get the feeling, judge, because the judge didn't ask for the church tax records, she only asked for 7M's records, right? So if the judge, for example, says, well, actually, they're separate entities, then everything that she's written about the church, well, there's two things. The way it would affect Katie is that if the judge says everything relating to the church is inadmissible, that means both sides then can't use anything and make it purely about 7M. But most of the statements have been made about Robert Shin and the thing about being a cult. So where she says 7M's a cult. So it gets murky, but you've got to have undisputable facts. So there is so much. Do you think her lawyers are advising her poorly? They told her not to settle. I think she thinks lawyers are a friend. Well, there is a correspondence initially where they did ask about settlement. And I just and them said no. A lawyer worth their weight in gold, in my opinion, is always trying to get some type of settlement, or is also always trying to get some type of agreement, because the more facts, the more things you can agree on in court, the easier it is. But as I said, there are so many disputable facts, whether she's a journalist, whether they're public figures, whether the church and 7M are same entities, whether because she's used them interchangeably. They recently stated lawyers, yes, but it's in a document. There's a letter from her lawyers to 7M lawyer saying they wanted to settle. So, but that was early on. All right, thanks, Mimi. So yeah, so in my view, there are too many disputable facts, like too many facts that can be disputed, and you can argue over these facts. You could spend a whole day in court arguing whether or not Katie Joy's a journalist. That could be a whole day's argument in court. Is without a crystal ball a media outlet. You could spend a whole day in court arguing over that. Is 7M with 7M and Shekinah Church the same entity? You'd spend a whole day arguing over that. But what often happens is they like to, generally there is a set of agreed facts, and there's not a lot of facts that they agree on. So if they could say, if they agree on, but if both parties could agree that they, like, Katie Joy is a internet blogger who makes YouTube videos, they could, if they agreed on that. See, the way that you deal with an internet blogger is different to how you would treat it if they were a journalist. Hello, short order. So hence why it's important to get all of these facts stated. But the fact that you've still got one side saying she's not a journalist and another side saying she is a journalist, it's a disputed fact. So I struggle to see how, unless the judge is prepared to make those decisions. So if for example, the judge says, I've decided that she's a journalist or whatever, I would then be asking to be able to refile some of my refile my documents. I'd be asking to refile my arguments, because you have filed your documents on the basis of one thing, but the judge has now said that. So you've done it on the basis of A, but the judge has now made a decision saying it's B, and you can actually go to the court and say, well, because you've made this determination, Your Honour, we need now to refile this document, or this reply, because this changes how we approach it. So if she says, for example, if she says that they're public figures, Katie Joy could, if she says, the judge says, well, Robert Shinn is not a public figure, Katie Joy then could ask, we would like to refile this document because we made the assumption that Robert Shinn was a public figure. We now need to relook at our argument. So can they appeal the ruling? They could appeal the summary judgment decision. You can appeal the decisions. Well, that's why I'm saying, Michelle, it's one of those, if they deem that she's a journalist, well, they possibly could. But essentially, if, for example, whichever way, whoever loses the summary judgment could actually appeal the decision, and it could go to Court of Appeal, which again extends it even longer. You see how court can go on and on and on? That's why it's always in the best interest of parties to settle. She's a sensationalist. That's what I'd say. And she's a sensationalist. And don't forget, if also the court was to deem her not to be a journalist, then essentially she would have to hand over all the confidential source information too, because she couldn't then say, I've got to keep my sources, I'm a journalist. The court turns around and says, well, you're not a journalist. Your evidence shows how credible she's got. I feel this will drag out and bankrupt her. I feel it will go another year or so. No true journalist acts like she does, says Short Order. Yeah, it's definitely interesting. I mean, they go on for years and years and years. So assuming that there is no appeal to that and it goes to trial, it's probably going to be towards the end of 2025, if not 2026. Let's be perfectly honest here. And sometimes they put it out for as long as they can in the hope that in the meantime it gets settled. So if I was, it's interesting, as of right now, neither party have made a motion that KJ is a journalist. No, and one has given, if I remember rightly, in Amber's filings, she wrote why she believed, why she couldn't be deemed a journalist. As I said, there's too many factors of dispute in and there has to. I'd love it if a working adjacent person would speak up on the family's current relationship with Jay. Yeah, like that too. All right. Well, I'm gonna have to go soon because I've got other stuff to do because it's New Year's Eve. I think I'm going out tonight too. Until there's something put in front, one cannot make a judgment one way. Well, that's right. As they came up with, unless both parties came and agreed that she was a journalist, then I don't know. But I don't, as I said, I don't know how. When you're talking about a summary judgment, I just think there's too many things that aren't clear. I think there's too many things the judge has to make determinations on. As I said, she may make a determination on them in her ruling. I did see that. She's sending love on. Gee, she's still going. She's still going on about her Instagram is full of Gypsy Rose stuff too. That's her. Look, Gypsy. See, this to me could be deemed as malice. My promise to Kelly Wilking is why I'm advocating for survivors. If she's found good as a journalist, there are no repercussions. She doesn't have a journalist certificate. She's not a journalist. Correct. And she has no insurance. Correct. There's no repercussions. There'll be a financial repercussion to her personally. Like, in most cases, publications have proper things in place, and they don't act like that. Well, here's the thing. Yeah, there's no if she was a journalist, there would be severe ramifications if she was found guilty. But there's none. And so, yeah. I think, but see, if the court says she's not a journalist, half her defenses go. She can't talk about qualified privilege. She can't then use the journalist's thing under Supreme Court ruling. She can claim to be a reporter. Now, a journalist is a different thing. Yeah, but she keeps talking about journalist and media outlet. They're not the same. And again, a media outlet generally, I mean, she's not in the same league as TMZ, you know? Now, when you think the guy that runs it is actually a lawyer, he knows how far he can push. He knows that he knows where he can push the boundaries and what ones he can step over because he knows he's a lawyer. So, and wasn't there something with Tucker Carlson under a ruling of something for him, and he wasn't deemed a journalist. He was able to he was something else. If you're well, I would have thought so. He was deemed an entertainment commentary writer. Correct. So she would be better using that line than a journalist. Or she would be best to say that she's a commentary She's a commentary channel. But because the word commentary gives you a little bit more leeway than saying, because then you're doing commentary on things. See, words matter, and rather than anyway, it just grinds me. Well, generally, they would be members of a professional organisation. Generally. Yeah, I think being an entertainment report, don't give her any ideas. You know, she watches. Shall I send her a bill then? But Aussie boy, I'm just also showing that I am trying to show both sides. I'm not showing a bias to 7M. I'm not showing a bias to Katie. I'm looking at both ways. And which you have to do as a lawyer. You have to look at how they could. She doesn't want to have a title that she doesn't and hasn't earned. So you have to look at bill her. So, for example, you would have looked at if we call ourselves journalists, ramifications, what are their arguments, an entertainment reporter, where are the cases where that's worked. So you have to start looking. You have to also put yourselves in the other side, in the other party's shoes, and try and work out what arguments they're going to do, and then try and counteract it. Hello, Justin and Phoenix. Well, see, can she call herself a media outlet? And so I just put media outlet in to see what we had as a definition there. So what is an example of media outlet? It can be television, news, social networks, newspaper, magazines. Full type more recent media outlet is the broadcasting channel providing news, information, and feature stories to the public by the way of newspapers, magazines, social media, and the internet, radio, and television. So again, is TikTok a media outlet? TikTok is not traditionally seen as a news platform. So again, it will come down to, is YouTube a media outlet? YouTube is a media platform rather than a news channel. If you're streaming, it's Striker. But people do get their news off TikTok. Correct. They do get it off. But here's the thing. It's a social media platform, actually. So she would be better off calling herself a social media influencer, actually. I know they get the news of it. I know lots of people get it, but is it accurate? But see, often the media outlets will put clips on, right? They'll snippets of it. So they might put in the headline with a picture, but then you have to go to their main page to get the full story. It's a difference. Yeah. It's definitely so when she's talking about, I don't know how she compares herself to Rolling Stones magazine, for example. I don't know how she can compare herself to the others. But anyway, look, I could be all wrong, and one of them gets a summary judgment. I don't know. I don't know. Again, there is a whole pile of documentation that's under seal at the moment, and we don't know what's in that. So we have no idea what's under seal, and we don't know. There could be some really damning evidence for one party sitting there under seal that we don't know about. So, only based on what we've seen so far. Anyway, I'm going to head off now. So I want to thank you for watching. It is now 2:27 on for just over an hour. I want to thank you for watching. Just put your thoughts in the comments below. Let me know what you think. Is Crystal Ball, would you class it as a media outlet? What do you think the chances of either side of being a summary judgment? What do you think? Yeah, just tell me what you think in general. And do you think that this is going to go on for another year? Possibly it could. There's 143 documents filed at the moment, on file at the moment. You got to think about it. Both sides have to read. Not only do both sides have to read that, the judge has to read it too. So there's a lot of reading to be done. So anyway, thank you for joining me, and I'll catch you again later. If I don't see you later tonight, hope you have a happy new year. And I'll see you next year. Bye for now.